So Stump v. Sparkman, 1978 SCOTUS decision. Stump v. Sparkman. This is Justice Stewart and Marshall and Powell's dissent. It is established federal law that judges of general jurisdiction are absolutely immune from monetary liability for their judicial acts, even when such acts are in excess of their jurisdiction and are alleged to have done maliciously or corruptly, says Bradley v. Fisher. It's also established that this immunity is no way diminished in a proceeding under 1983 Pearson v. Ray. But the scope of the judicial immunity is limited to liability for judicial acts. And I think that what Judge Stump did on July 9th, 1971 was beyond the pale of anything that could be sensibly called a judicial act. And then Bradley versus Fisher. So you know what? Judges can't even be sued. Even when they're malicious or corrupt, that doesn't make any damn sense whatsoever. Bradley v. Fisher, that had to do with the assassins of Lincoln, Abraham Lincoln. Why would Bradley v. Fisher be on the side of wrong? And then Pearson v. Ray, that's another stupid decision. So Pearson v. Ray, there was a bunch of clergymen who was arrested for breaking segregation statutes. You're going to claim immunity because of a case where they broke segregation statutes? But the scope of judicial immunity is limited to liability for judicial acts, and I think that what Judge Stump did on July 9th, 1971 was beyond the pale of anything that could sensibly be called a judicial act. Neither in Bradley v. Fisher nor in Pearson v. Ray was there any claim that the conduct in question was not a judicial act, and the court thus had no occasion in either case to discuss the meaning of the term. What is a judicial act? Yet the proposition that judicial immunity extends only to liability for judicial acts was emphasized no less than 7 times in Justice Field's opinion for the court in the Bradley case. Embler v. Pachman. And if the limitations inherent in that concept have any realistic meaning at all, then I cannot believe that the action of Judge Stump in approving Mrs. McFarland's petition is protected by judicial immunity. Maybe I need to tell you what Stump v. Sparkman is about. Stump v. Sparkman. So you got Judge Stump, right? He approved a petition to sterilize the daughter of the petitioner. So you have this Ora McFarland comes in and says, "Oh, my daughter, she's just hoeing around. She's a hoe and she's a whore and a total slut. And since my daughter's a whore and a slut and a hoe, well, we need to sterilize her. And then, oh, by the way, she's got a low IQ, so she's probably, mentally degraded." 1978, this is sterilization. This is what Hitler was doing. Why the hell would the United States government, why would the Supreme Court go ahead and say that sterilization is okay in Stump v. Sparkman? If somebody says, well, you know what? I got immunity because of Stump v. Sparkman, laugh in their damn faces. Because clearly Stump v. Sparkman is the worst decision ever on the planet Earth. So you have Linda Sparkman. Linda Sparkman is going to get sterilized. She was just a kid. She didn't have notice. When they told her about the operation, she didn't have notice. They didn't even put the damn petition into the file. And then the judge didn't even sign his name. He just signed it, the clerk, the judge of the county or whatever. He didn't sign his name to it because he knew himself he wasn't going to put his name on such a stupid-ass decision. That makes no sense. The parent comes in and says, hey, my daughter is a whore, so you need to sterilize her. And then the judge signs that fucking petition. And then the mother, in order to get Linda K. Sparkman, in order to go to the operation, she says, oh, it's to get your appendix out. So she lied straight to her daughter's face. And then she's not going to find out until she gets married later on and she wants to have children. They sterilized her. They didn't just kill her, future. They killed her being a mother. They killed her genetics. They killed her legacy. James Joyce says that the point of life is to outlive your life. And to have children would be a way to outlive your life. They prevented Linda K. Sparkman from outliving her life. So the Stump v. Sparkman decision of 1978 is one of the worst damn decisions that the Supreme Court that SCOTUS could ever come up with. It's one of the worst damn decisions ever. The court finds 2 reasons for holding that Judge Stump's approval of the sterilization petition was a judicial act. How was a judicial act? Well, the guy was wearing a robe. He was wearing a robe, and he says, e pluribus unum. He spit out some Latin phrases, and he had a damn robe. First, the court says it was a function normally performed by a judge. Oh, to approve a sterilization of a daughter without giving her notice, without giving her any due process, without even holding a hearing, without even getting her a guardian ad litem, without even giving her any kind of representation. You just went ahead and approved her, ex parte with the mother. She wasn't even there. She never was informed about it. And the mother drives her to the damn hospital, and then 3 fucking doctors go ahead and sterilizes poor Linda K. Sparkman. What kind of sick fucking shit is this? And then you want to say, well, I got judicial immunity because of that Stump v. Sparkman case, huh? So that case that they sterilized that poor girl, because the mother said that she was a whore? That fucking case where you had 3 doctors and a judge, you had all these so-called adults that went ahead and sterilized this young woman, not because she, did anything wrong. She wasn't a criminal. She didn't injure anybody. She didn't hurt anybody. Just because they had a hard-on for sadistic fucking retribution against somebody that didn't even harm them. Talk about a weird-ass revengeful streak. They want to declare revenge against somebody that didn't even do a damn thing to them. It's like this Judge Stump just couldn't tell this Ora McFarland no. Well, you did come in here and you do have this petition and you signed your name real pretty. How's that a judicial act? A function normally performed by a judge. Secondly, the court also says that the act was performed in Judge Stump's judicial capacity. With all respect, I think that the first of these grounds is factually untrue and the second is legally unsound. When the court says that Judge Stump, why are we still putting judge in front of his name? Stumpstein was an act normally performed by a judge. It's not clear to me whether the court means that a judge normally is asked to approve a mother's decision or to have her child given surgical treatment generally, or that a judge normally is asked to approve a mother's wish to have her daughter sterilized. That's a shitty fucking mother. Hey, can you go ahead and sterilize my daughter? Why is that? Well, she's getting to that age where she likes sex. You wouldn't have had her if you didn't like sex. Sex is how we all got here. Jesus fucking Christ. These motherfuckers are, what are they pretending, like they're like prudes? Like they're, what, a bunch of eunuchs? Were they all sterilized? Was Stump? I mean, he clearly was sterilized in the head. This was an act normally performed by a judge. Get the fuck out of here. Whichever way the court statement is meant to be taken, it's factually incorrect. Why? Because in Indiana, that's where this happened, right? The land of Indians, as elsewhere in our country, a parent is authorized to arrange for and consent to medical and surgical treatment of his minor child. And when a parent decides to call a physician to care for his sick child or arranges to have a surgeon remove his child's tonsils, he does not normally or otherwise need to seek the approval of a judge. If the person is just sick, well, then you just go ahead and take care of the sickness. No, you went to a judge in order to cover up your ass, to cover up the liability, and then we're going to go ahead and say, well, judges can do whatever the hell that they want to do. Donald says he's never ignored a judicial court order, but he just ignored a court order. So he's starting to ignore court orders, and then when he starts to ignore the judicial branch, well, he wants to be a dictator, right? So you got to get rid of the Congress, you got to get rid of the legislative branch, get rid of the judicial branch. You're aiming to be a dictator, right? They asked him, would he ever ignore a court order? He already did, so he says no, but these damn activist judges and their stupid court orders, eventually it has to get to the Supreme Court. You want to ignore the court order? Aren't you a fascist as well? You have another fascist, right? One fascist cancels out another fascist. Who wins? In Indiana, as elsewhere in our country, a parent is authorized to arrange for and consent to medical and surgical treatment of their minor child. If they have a sickness, then the doctors will take care of the sickness. They got a court order because they knew they weren't taking care of a sickness. They were going to do harm to this girl. Poor Linda K. Sparkman. Linda K. Sparkman didn't have a damn chance because she was born to a dumbass. Maybe her mother was a whore too. On the other hand, Indiana did in 1971 have statutory procedures for the sterilization of certain people who were institutionalized. And again, there was no hearing. So this is just a mother's accusation against the daughter. Does this sound like a good mother to you? First, she's sitting there calling her daughter retarded, and then she's also saying that her daughter needs to be sterilized because she's getting in cahoots with men. She's starting to get interested in the boys her own age. I think it's fucked up if you think that's fucked up. My daughter is interested in boys her own age, so we need to go ahead and sterilize her. You think that makes a lot of sense, you sick fuck? You should have laughed right at Ora McFarland's petition, laughed right in her damn face and tell her to get the fuck out of your courtroom. So there was actually procedures for sterilization when people were institutionalized. Linda K. Sparkman wasn't institutionalized. She had no order against her. She wasn't deemed mentally incompetent. She wasn't deemed a criminal. She just had a shitty mother. That's the only thing she was guilty of. So because Linda K. Sparkman had a shitty mother, she got sterilized. Ora McFarland needs to be sterilized, and so should this fucking Judge Stump. Judge Stump should be sterilized. So that way he won't be using his stump anymore. Not for any procreation purposes, but these statutes provided for the administrative proceedings before a board established by the superintendent of each public hospital. This never happened. None of this happened. No administrative proceedings happened for Linda K. Sparkman before a board established by a superintendent of any public hospital. And only if, after notice and an evidentiary hearing, an order of sterilization was entered in these proceedings, there could be a review in a circuit court. She couldn't even appeal the damn decision because there wasn't even a public decision for her to appeal. She didn't have a notice. There was no evidentiary hearing. There was no finding of her being a whore or her being, incompetent. She wasn't a criminal, so she wasn't. You can't say that you want the sterilization because she just keeps on committing crimes. This is one of the most disgusting fucking decisions in the history of mankind, let alone America. In sum, what Judge Stump did on July 9th, 1971 is in no way an act normally performed by a judge. Indeed, there is no reason to believe that such an act was ever performed by any other Indiana judge, either before or since. No fucking judge has ever just took the word of a damn mother and went ahead and issued a petition to sterilize her daughter without an evidentiary hearing, without any kind of hearing, without probable cause, without a grand jury indictment, without institutionalization. There was no formal notice, no due process, no jury trial, no designation of institutionalization, no designation of her being a habitual criminal or a person who is needing to be sterilized in any way, shape, or form. She wasn't incompetent. There was nothing. Maybe Ora McFarland was a whore. Maybe she was sucking Judge Stump's dick. Why the fuck would Judge Stump approve of something so stupid? How is this a judicial act? How is this him acting in his judicial capacity? Because he was wearing a robe? He was wearing a robe and he's sitting up on high? He's sitting up on Mount Sinai with a damn robe. And he's got a gavel. Is that all it takes to be a damn judge? I don't like Andrew Jackson, but then when the Supreme Court ruled against Andrew Jackson, he says, okay, you made your ruling, so why don't you go ahead and enforce it? Yeah, I think Judge Stump should have fucking enforced his own sterilization. But because she had a shitty mother, Linda K. Sparkman didn't know to distrust her own damn mother. No, disobey. Disobey your stupid ass mother. Do not go for this appendicitis. It's not an appendicitis. They're not trying to get your appendix out. She's a fucking liar. She's lying straight to your face. Probably because she doesn't want to lose her daughter. Her daughter's going to fall in love with some young man, and then that, young man is going to love her and then want to marry her and then, have a family. And so this Ora McFarland didn't want to let go of her child because she owns her child, right? You own your own child, right? They're not their own person. You own your child, right? What Judge Stump did on July 9th, 1971 was in no way an act normally performed by a judge. Nothing like that has ever happened before or after. So if something was done by a judge that no judge has ever done before or after, you know something was fucked up. How is this within his judicial capacity? How is this a legitimate judicial act? Well, he was wearing a damn robe and he had a gavel. And then he hit the gavel on the damn... Yeah, anybody could wear a fucking black robe. Anybody could hold a gavel in their hand. Anybody could sit up on Mount Sinai and issue out opinions. When the court says that Judge Stump was acting in his judicial capacity in approving Mrs. McFarland's petition, it's not clear to me whether the court means that Mrs. McFarland submitted the petition to him only because he was a judge, or that in approving it, he said that he was acting as a judge. However the court's test is to be understood, it's demonstrably unsound. It's unsound. It can safely be assumed that the court is correct in concluding that Mrs. McFarland came to Judge Stump with her petition because he was a county circuit court judge. But false illusions as to a judge's power can hardly convert a judge's response to those illusions into a judicial act. If you just put robes on a fool, and you give a fool a gavel and let him sit up on the bench, that means anything that motherfucker says and does is part of a judicial act to be protected. That's a legitimate judicial act. That's within his judicial function. Get the fuck out of here. Get the fuck out of here. Even if he was appointed, even if he's democratically elected. Just some asshole spouting off fucking opinions. You have to be a good judge. You have to be fair and balanced. You got to be even-handed. The whole point of the law is to prevent one person from injuring another person. Did Linda K. Sparkman injure anybody? No. But Ora McFarland injured Linda K. So did Judge Stump, and then so did those 3 doctors. And of course the mother's going to lie because they know they're doing evil. Of course he didn't sign his name. He didn't even file the fucking claim because he was doing evil. Of course he didn't want any proceedings or a hearing. He didn't want an evidentiary hearing because he was doing evil. Stump v. Sparkman, 1978 is an evil, wicked decision. So if any judge ever says, well, I get immunity because of Stump v. Sparkman, fuck you, you stupid. If anything, you should laugh, or anything, don't say anything, because they just picked the worst goddamn case that they could possibly pick. The Pearson v. Ray, is that going to be the next one? Well, according to Pearson v. Ray, so if black folks want to go to a segregated, town with a bunch of racist, hierarchical bullshit fucking, and then the arrest is made and the judge goes along with it, immunity for everybody that just fucked over segregation, it was bullshit. Black folks are people too. If you've concluded otherwise, you're fucking stupid. You think the world is flat too? You think the earth revolves around the sun? You think 1 + 1 equals hamster doodle? 1 + 1 equals 2. 1 + 1 doesn't equal hamster doodle. In short, a judge's approval of a mother's petition to lock her daughter in the attic would hardly be a judicial act simply because the mother had submitted her petition to the judge in his official capacity. That's not even that great of an example. If a mother wanted to come into a courtroom and try to get a petition to throw the daughter over a cliff, if the mother wanted to go into a courtroom and get a petition to chop off one of her daughter's legs, why? Because she's a whore. She keeps running around with all these. If you cut off one of her legs, that'll severely hamper her efforts to whore around. And what's wrong with being a whore? That's not breaking any laws. If, on the other hand, the court's test depends upon the fact that Judge Stump said he was acting in his judicial capacity, it's equally invalid. It's true that Judge Stump affixed his signature, not his real signature, to the approval of the petition as judge. He signs judge to call the circuit court. He couldn't even put his own fucking name on it. He just put his title on it. Signed by Judge DeKalb Circuit Court. The conduct of a judge surely does not become a judicial act merely because of his own say-so. A judge is not free like a loose cannon to inflict indiscriminate damage whenever he announces that he's acting in his judicial capacity. Any asshole, Abigail Adams says that any man would be a tyrant if you let him. Any person, any woman would be a tyrant. Anybody would be a tyrant if you let him. If the standard adopted by the court is invalid, then what is the proper measure of a judicial act? Contrary to implications in the court's opinion, my conclusion that what Judge Stump did was not a judicial act is not based upon the fact that he acted with informality, or that he may not have been in his judge's robes or in the courtroom itself. He wasn't even in his judge's robes. He wasn't even in the courtroom. Did he even have a gavel? What the fuck was his judgment? He was just an asshole, fucking thumb up his own ass while he was sitting on the couch, and he's like, yeah, I think we should sterilize Linda K. Sparkman. Linda K. Sparkman had a book about she holds a blanket or something because she holds the blanket of the daughter she can never have. And in A Time to Kill, that was what happened to the daughter. The daughter got raped so bad that she couldn't have any kids anymore. That's what these motherfuckers did. A Time to Kill shit. And I do not reach this conclusion simply because the petition was not given a docket number, was not placed on file with the clerk's office, was not approved in an ex parte proceeding without notice to the minor, without a hearing, without the appointment of a guardian ad litem. They didn't even put the file in the fucking filing cabinet in the clerk's office. It wasn't even given a docket number. It seems to me rather that the concept of what a judicial act must take its content from a consideration of the factors that support immunity from liability for the performance of such an act. If a judge can't even be goddamn sued because he got a poor girl sterilized before she was even of the age of consent, before she was even an adult, fuck that shit. Fuck that shit. When you make peaceful revolution impossible, then you make violent revolution inevitable. What else could Linda K. Sparkman have done? She should have ran away. She should have ran away. She should have rebelled. She should have resisted. But instead, because she was a good, dutiful daughter, she's going to get her tubes tied, and she's not going to be able to have any damn kids. Because she had a shitty fucking mother. And they were living in a corrupt fucking county with a corrupt fucking judge and a bunch of shitty doctors. Nobody with any common sense. Nobody with any empathy for other people. Those factors were accurately summarized by the court in Pearson v. Ray. It is, and I quote, for the benefit of the public whose interest it is that the judges should be at liberty to exercise their functions with independence without fear of consequences. Yeah, they should be independent. And they shouldn't fear the consequences for their good rulings, right? If you have a criminal going around criminalizing people and somebody wants to sue that person because they didn't get justice, that's a good ruling. They should be protected by their good rulings. But they shouldn't be protected by their bad rulings that hurt people. The point of being a judge is not to go around inflicting injury upon other people. The point of a judge is to make sure that justice happens. Let justice reign, or the mighty waters of, what did MLK say? It's a judge's duty to decide all cases within his jurisdiction that are brought before him, including controversial cases that arouse the most intense feelings in the litigants. His errors may be corrected on appeal, but he should not have to fear that unsatisfied litigants may hound him with litigation charges, charging malice or corruption. Imposing such a burden on judges would contribute not to principled and fearless decision-making, but to intimidation. So we're more worried about hurting the judge's feelings than to make sure that the judge acts fucking right. This is such bullshit. This is such bullshit. The whole point of the 1983 cases was because in the deep, dirty South, right after the Civil War, the civil rights of black folks were not being upheld. And so the federal government is allowed to impose upon the states to enforce the freedoms that are listed in the Bill of Rights because the states weren't fucking doing it. And so what else can you do if you don't have a federal remedy, if you can't go to the federal courts to make sure that the state officials, and then who in the state is at most, who at the state level is at the position that most likely could deprive the person of their civil rights? If it's not the cops, then it would be the fucking judge. So to think that the 1983 cases, 42 U.S. 1983 cases were not put into practice in order to stop fucking judges to committing crimes and depriving people of their civil rights, like the right to due process. They didn't even hold a fucking hearing. They didn't even have a notice. She would have won her habeas corpus hearing. She would have won the evidentiary hearing. No grand jury would have fucking indicted this shit. They skipped all the fucking legal fucking hearings that they needed to have to go straight to do some crimes. Well, the judge signed a piece of paper, the doctor said. Judges sign a piece of paper, and then that could be looked at as an order. Even if you give permission for something, that doesn't mean that you should go ahead and do it. A lot of goddamn adults fucked over Linda K. Sparkman. Not one of the considerations thus summarized in the Pearson opinion was present here. There was no case, controversial or otherwise. There were no litigants. There was no trial. There was no opponents, no parties, no lawyers. There was and could be no appeal. There was no docket number. They didn't even have a thing in the damn filing cabinet. Just a guy signed a fucking piece of paper. Some asshole signed a piece of paper and then she got her fucking tubes tied. Tubal ligation. Is that just tubes tied, or did they remove her tubes? They took out her fallopian tubes because some asshole with the thumb up his ass sitting on the couch signed a piece of paper? How the fuck is that a judicial act? How is that normal fucking judicial functions? And to think that a judge who is malicious or corrupt, who caused an injury, shouldn't be held liable? Get the fuck out of here. Anybody who injures anybody should be fucking liable. Yeah, it could be abused. It could be abused. But then it could be abused the other way. To give immunity to a judge no matter what the fuck he does is to allow him to abuse anybody else. So the rule is typically judges have immunity, but there's exceptions to all rules. Not one of the considerations thus summarized in Pearson opinion was present here. There was no case, controversial or otherwise, no litigants. There could be no appeal, and there was not even the pretext of principled decision making. There wasn't a pretext of principled decision making. They didn't even say, well, based upon this goddamn statute, based upon this precedent. No, he probably was just, he got his dick sucked, right? Or McFarland had to have been the whore. Shit, every accusation they say is a fucking confession. So she's sitting there saying that her daughter was mentally incapacitated. Her daughter was somewhat retarded. That's what was put in quotes. And that she was a whore. Maybe Orla McFarland was the one talking about her damn self, and it was Orla McFarland that needed to be sterilized. And it was Judge Stump that needed to be sterilized, and the 3 fucking doctors who need to be sterilized. Because what kind of person with a conscience could even go through with this shit? Oh, you think you deserve immunity because of Stump v. Sparkman, huh? You sick fuck. The total absence of any of these normal attributes of a judicial proceeding convinces me that the conduct complained of in this case was not a judicial act. The petitioner's brief speaks of an aura of deism which surrounds the bench, essential to the maintenance of respect for the judicial institution. Yeah, because he's a deity, he's a god, he's infallible, he can do no wrong. To err is human. That motherfucker is human. He's sitting on a couch with a thumb up his ass and he signed a piece of paper. That could be a fucking evil goddamn act. And evil acts is not a judicial act. It is definitely not a judicial act worthy of defending by anybody, anywhere, at any time. Though the rhetoric may be overblown, I do not quarrel with it. But if there be, it is hardly protected by exonerating from liability such lawless conduct as took place here. And if intimidation would serve to deter its recurrence, that would surely be in the public interest. In the Bradley case, the plaintiff was a lawyer who had been disbarred. In the Pearson case, the plaintiffs had been found guilty after a criminal trial. The general authority of a parent was held by an Indiana Court of Appeals in 1975 not to include the power to authorize the sterilization of a minor child, his minor child, AL versus GRH. So the precedent said that you couldn't do it. No, you can't just sterilize your child, you asshole. That's according to the law, but the guy didn't give a fuck about law, he didn't give a fuck about the statute, he didn't give a fuck about the Constitution. The guy just pulled a fucking decision out of his ass and then got this poor girl, her insides fucked up where she could never have kids ever again. That is some time to kill shit. The time to kill. That poor girl was raped so bad she could never have kids ever again. And what did Samuel L. Jackson do? Well, he showed up to the courtroom with an AK-47. And he established justice. And then when he was put on trial, they asked him, do you think they deserve what they got? And he says, yeah, I do, and I hope they burn in hell. Contrary to the court's conclusion, something in that case does not in the least demonstrate that an Indiana judge is or ever was empowered to act on the merits of a petition like Ora McFarland's. The parent in that case did not petition for judicial approval of her decision, but rather filed a complaint for declaratory judgment seeking declaration of her right under the common law attributes of the parent-child relationship to have her son sterilized. Under the common law, I'm going to talk about the common law soon. The Indiana Court of Appeals decision simply established a limitation on the parent's common law rights, neither sanctioned nor contemplated any procedure for judicial approval of the parent's decision. Indeed, the procedure followed in that case offers an instructive contrast to the judicial conduct at issue here. At the onset, we thank counsel for their excellent efforts in representing a seriously concerned parent and providing the guardian ad litem defense of the child's interest. Yeah, if you're going to try to do anything to a child, then you're going to need to have a lawyer present. So that way the lawyer can tell the child all their rights and all the things that they deserve under the damn law. You're going to make a decision to do something to a child, and you're going to sit there and then hide behind your robe, try to say that it was a judicial act. You were acting within the jurisdiction of your judicial capacity. These words haven't been defined. What is a judicial act? Nobody fucking knows. What is signing your name? Is that a judicial act? Within your jurisdiction. So if he wasn't a probate judge, he was a circuit court judge. So I guess he's got all the rights to do whatever the fuck he wants. He's still bound by the law. He's still bound by precedent, the Constitution, and the statutes. He is bound by law. So at the very least, a judicial decision, a judicial act would be something that is consistent with the laws of the fucking state that they live in. I do not need to inquire whether he was acting in the clear absence of all jurisdiction over the subject matter. The clear absence of all jurisdiction. They are making this definition so sweeping, it's not even funny. Well, if you're a probate judge, then you're just supposed to do things about the will, right? Just to affect the wills of the estate. Right now, Gene Hackman just died, so that's going to go to a probate judge. So a probate judge can't act like a criminal judge. A probate judge can't try a murder trial. So that's it. That's the only fucking exception. That's the only limit to the power of a judge. There's limits to all things, and power is not the rule in America. Freedom is the rule. And clearly, Linda K. Sparkman's rights were infringed upon. Man, 50 minutes. Jurisdiction is a coat of many colors. I note only that the court's findings that the Judge Stump had jurisdiction to entertain Mrs. McFarland's petition seems to me to be based upon dangerously broad criteria. Those criteria simply that an Indiana state statute conferred jurisdiction of all causes, matters, and proceedings. The only question before us in this case is the scope of judicial immunity, how the absence of a judicial act might affect the issue of whether Judge Stump was acting under the color of state law within the meaning of 1983, or the issue of whether his act was that of the state within the meaning of the 14th Amendment need not therefore be pursued here. Mr. Justice Powell dissenting. While I join the opinion of Mr. Justice Stewart, I wish to emphasize what I take to be the central feature of this case, Judge Stump's preclusion of any possibility for the vindication of respondents' rights elsewhere in the judicial system. Bradley v. Fisher, 1872, which established the absolute judicial immunity at issue in this case, recognized that the immunity was designed to further the public interest in an independent judiciary, sometimes at the expense of legitimate individual grievances. Accord Pearson v. Ray. The Bradley court accepted those costs to aggrieved individuals because the judicial system itself provided other means for protecting individual rights against the consequences of judges' erroneous or irregular action from whatever motives preceding the law has provided for private parties numerous remedies, and to those remedies they must in such cases resort. Underlying the Bradley immunity, then, is the notion that private rights can be sacrificed in some degree to the achievement of the greater public good deriving from a completely independent judiciary because there exist alternative forms and methods for vindicating those rights. But where a judicial officer acts in a manner that precludes all resort to appellate or other judicial remedies that otherwise would be available, the underlying assumption of the Bradley doctrine is inoperable. See Pearson v. Ray. In this case, Mr. Justice Stewart points out Judge Stump's unjudicial conduct ensured that there was and could be no appeal. The complete absence of normal judicial process foreclosed resort to any of the numerous remedies that the law has provided for private parties. Bradley. In sum, I agree with Mr. Justice Stewart that petitioner judge's actions were not judicial and that he is entitled to no judicial immunity from suit under 42 U.S.C. 1983. In both Bradley and Pearson, any errors committed by the judges involved were open to correction on appeal. That's another reason to say that you can't sue the judge because, well, there's an appeals process. There was nothing to appeal in the Linda K. Sparkman case. To say that Stump v. Sparkman is your go-to case is to say that you're fucking dumb and you looked at an evil case, and even though the holding of the evil case was wrong and terrible, of a case that was awful, it was good enough for you. Well, the devil went ahead and just mass murdered, a whole bunch of kids? What was it? Netanyahu just killed 404 kids in Bethlehem, and then 53 Yemenis were killed, and then hundreds of Ukrainians are being killed right now. So the devil went ahead and approved of mass murder of a bunch of children. Well, if the judge said that it was okay, well then shit, he deserves judicial immunity for that decision. I can't think of a worse goddamn decision. You just justified fucking genocide. You just put the cover of law upon genocide. Do you have any red lines whatsoever? And that's Stump v. Sparkman, 1978. The Dissents of. Wait, now it says 37. I thought it said 50 from before. Is it 50 or